Good morning, everyone. Welcome to this panel, this UASIS panel. It's a non-traditional panel. The aim of this panel is to present the anniversary issue, the 25th anniversary issue of the European Foreign Affairs Review. And this is titled The Future Partnership between the UK and the EU. We have collected a number of experts to contribute to this special issue, and we have the honor of presenting part of the articles of the anniversary issue today. We will have a number of illustrious speakers. Jörg Monar, who is my co-director of the European Foreign Affairs Review, will be briefly introducing the anniversary issue first. And then we'll have Sieglinde Gstöhl from the College of Europe, who will be speaking on the EU as an actor after Brexit. Will it be a stronger actor or will it be a more feeble actor? After that, we will have Peter Holmes from Sussex University, who will address the topic Brexit and trade relations between the European Union and the UK, I understand. Catherine Barnard, University of Cambridge, will be addressing mobility rights between the two countries after Brexit. And finally, David Finnemore of Queen's University Belfast will be addressing the issue of Northern Ireland and whether that will be an Achilles heel in the new partnership between the EU and the UK. So the aim of this anniversary issue is to identify certain issues which will remain on the agenda for some time to come on the agenda of the European Union. So the aim is to discuss which are important issues which are brought about by Brexit. Also today's aim is to present to you a new editorial team for the European Foreign Affairs Review, and that will be done at the end after a debate on the 4 papers. So we'll come to that later. Jörg, can I give you the floor to present the anniversary issue?
Yes, thanks very much, Nanette. Dear colleagues, I would also like to welcome you to the panel and to thank you for having accepted to contribute. Now, for the European Foreign Affairs Review, it's a special year, 25th anniversary. If I may just briefly say, the review was founded in autumn 1995, and it was actually founded in the UK. So at that time, Clever Law International had actually a subsidiary in the UK, and the agreement setting it up was actually signed in Sterling House, 66 Wilton Road in London. So from this perspective, you can say it's a British journal by origin. Now, obviously, at the time, none of us, David O'Keefe and myself, who were the initial editors, would have thought that it would come to the UK leaving the European Union. At the time, it looked as if the United Kingdom was, of course, a very important shaping element of EU external relations, and a lot of the articles which were published in the first years obviously also then dealt with aspects related to the key role of the United Kingdom in EU external relations. Now, Nanette and I had to take a decision about a subject for an anniversary issue of the European Foreign Affairs Review. We considered various other options, but ultimately we felt the leaving of the United Kingdom and the need to actually build up a completely new relationship with a former major member state was such a momentous development that it was an obvious theme to be chosen. The panel we have now with 4 papers is not the complete, does not represent the complete anniversary issue. I would like to mention that other articles to be published deal with the justice and home affairs dimension by Christian Kaunert and Sarah Leonard from the University of South Wales. Professor Jan Wouters from the KU Leuven will contribute a paper on the institutional dimension, and Professor Thomas Appleby from the UWE Bristol will contribute an article on the fisheries dimension, which is one of the complex issues in the relationship, clearly. We also had invited a colleague whose name I will now not give because we are not sure that he will in the end deliver the paper on the security and defense dimension. I think the colleague might have been slightly discouraged by the unwillingness of the British government to really engage thoroughly in the security and defense relationship with the European Union. So I have a certain understanding for that. Now, let me say that the European Foreign Affairs Review in the 25 years of its existence has actually always tried to look at all aspects of the external posture of the European Union, and this in a multidisciplinary way. It is a journal which is linked to and based at Kluwer Law International, so the legal dimension was always prominent in the context of the journal. But we have had, I would say, a majority of contribution from international relations, from political science, from law, as I already said, where we always had to struggle, and I admit this fully, is to have contributions from economists. And I'm also more happy that Peter Holmes and Jim Rollo have agreed to contribute. So it's one final effort of us editors to bring the economic dimension out. Thanks for that. I wouldn't like to take much more time, but I would like really to thank those who are contributing to this issue, because the negotiations have clearly not made much progress in the meantime. So this means you had all to work in the context of very considerable uncertainty. And all of you contributing the articles had to some extent to be speculative. And of course, you are all serious senior academics, and normally speculation is not what you like to do. So nevertheless, you have stayed on board, and all our appreciation on the side of Nanette and myself for having stayed on board. And the papers are now there, and personally I think they're really very, very good. So having said this, I pass the word back to Nanette. You are unmuted. You are muted, Nanette. You are muted.
Sorry about that. I pass the floor directly to Sieglinde Gstöhl, who will be presenting on the EU as an international actor after Brexit. Sieglinde, go ahead.
Yes, thank you very much. So we come to the first speculation, if I may say so, about whether the EU without the UK is going to be a weaker or stronger international actor. So with the UK's departure, the EU lost one of its 3 biggest member states in terms of population and GDP, the 2nd largest net contributor to the budget, and one of its only 2 military powers with a full spectrum military capability, including nuclear arms and a permanent seat in the United Nations Security Council. It also lost a member with historical special relationships with the United States and the Commonwealth countries. Now, this has led many observers to consider that Brexit would deliver a serious blow to the EU's global image and to its soft power or influence, in addition to the previous crises, such as the refugee and migration crisis and the sovereign debt crisis, thus adding further to the perception that the EU is a declining power. Now, the question is thus whether this really holds up and what the likely impact of Brexit on the EU's role in world politics will be. In the paper, I argued actually that post-Brexit, the EU remains a relevant player in world affairs and even has the potential to become a stronger international actor. And the paper does so by drawing on two prominent approaches from EU external action studies: actorness as a concept, I should say, and role theory. Because in order to be able to play a significant role in international politics, the EU needs a certain degree of actorness in various fields. Drawing on the definition by Bretherton and Vogler, which have provided one of the most commonly used definitions of EU actorness as being composed of three dimensions: presence, or the EU's capacity to, by virtue of its existence, to exert influence beyond its borders; then opportunity, that's the external context shaping EU action; and finally capability, that's the internal context, which encompasses both structural elements such as the availability of appropriate instruments and the perceptions of the EU by the other actors. Now, roles are basically patterns of expected or appropriate behavior, which are shaped by an actor's own role conception, like how an actor perceives itself and its relative position, and by the role expectations of others. So how the other actors perceive the role beholder and expect it to behave. Now, so what does that all mean for the EU's presence at 27? The paper pays particular attention, I should say, to the EU in comparison to the two other major powers, the United States and China, and also to three key external policies: trade, development, and security defense. Of course, again, the disclaimer, there's a key uncertainty in this. That's the future UK-EU partnership agreement in terms of substance and governance, and how, even if it will be basic at the beginning, how this will then evolve in the following years. So we don't know. But let me say that if just looking at the statistics, EU 28, EU 27, and compared to the US and China, after Brexit, the EU still has the third biggest population. It accounts for the second largest share of global GDP. It's the largest exporter of goods and services, in particular services, and the largest provider and destination of foreign direct investment. Although some of the American or Chinese shares are actually very, very close to the EU's relative position. The euro has become the second most important currency despite the crisis. For example, if you look at the currency shares in foreign exchange reserves, also the UK obviously was not a member of the Economic and Monetary Union. And I should also say that the EU plus its 27 member states, sorry for that slip, together are still the largest donor of official development assistance. So presence can also be enhanced by attractive values and what we generally call soft power. And in this respect, it's interesting to look at the Soft Power 30 Index, which ranks 30 countries, among which are 16 EU member states. And in that ranking, France, the UK, and Germany occupy the three top positions, with the United States 5th and China in 27th place. And also in terms of the number of diplomatic posts, a ranking which is led by China and the US shows that in comparison, the European External Action Service comes right after India in 13th place. And as Scott Brown has contended in an article on this aspect, such indices may also help reveal that taking the UK out of the EU's soft power equation does not necessarily significantly alter the balance. Now, when it comes to hard power, the military expenditure of the EU member states combined, not of the EU obviously, is, according to SIPRI figures, with about 13% comparable to China's, from what we know, but far from the US share, which is about 34%. And we also have to keep in mind that 21 of the 30 members of NATO are members of the EU. The EU as such is obviously not a military power, but it has indeed developed some presence in this regard with currently, I think, 6 military missions and operations and 11 civilian missions ongoing under the CSDP and a deployment of about 5,000 persons. The UK has in the past contributed to such missions and operations, but to a rather limited extent, I would say. So overall, the presence of the EU27 remains impressive. Now, how does this presence translate into role conceptions of the EU? As you all know, the debate about what kind of power or actor the EU is in international affairs has mainly been marked by concepts such as civilian power or normative power. And the Lisbon Treaty, for instance, in Article 21 TEU, indeed conceives of the EU as a promoter of norms, such as democracy, rule of law, human rights, etc., and of multilateralism. Other conceptions, for instance, Damrow talks about the EU as a market power, which exercises its power through the externalization of economic and social market-related policies and regulatory measures, also unintendedly, and to what Bradford, for instance, calls the Brussels effect. And I think in the context of Brexit, this role has been further enhanced by a strong focus in the negotiations on ensuring a level playing field. Moreover, as an additional role, or maybe emerging one, the global strategy, in the global strategy, the High Representative Mogherini argued that the idea that Europe is an exclusively civilian power would not do justice to an evolving reality given its military and civilian operations. And she wrote that for Europe, soft and hard power go hand in hand, and that our partners expect the European Union to play a major role, including as global security provider on the horizon, let's say. So in sum, I think when it comes to EU presence, it has generally shrunk with Brexit, but it's still very impressive, and the EU continues to be a strong market or trade power and norm promoter, and it aspires in addition increasingly to also act as a security provider. Now, what about the opportunities, the second aspect of activeness? The international order has been undergoing important geopolitical shifts. The economic structure has essentially become tripolar with the EU, the US, and China, as I said in the beginning, while the multilateral system with the WTO has been weakening. Now, the international security landscape has become more volatile with new conflicts, especially also in the neighborhood of the European Union, new hybrid threats, etc. And the three major poles here are rather the US, NATO, Russia, and China. So the relative withdrawal of the United States under President Trump from participation in many multilateral fora, and also the more assertive great power politics of China and Russia, have fueled a quest in the European Union for more economic sovereignty and strategic autonomy. And therefore, it's not surprising that the new European Commission under President von der Leyen has branded itself as a geopolitical commission. Now, a geopolitical approach generally does not separate economic from political, maybe even military tools. And the global strategy also stresses the need to become a more joined up actor in general. So new opportunities are thus arising from global developments which are not directly related to Brexit, but rather due to a confluence of developments, in particular US foreign policy under President Trump. But also we should keep in mind from the fact that the UK has in the past, as a member, simultaneously been a source of capabilities for the Union, but also a constraint in some parts on its external action. So finally, new opportunities might perhaps also arise as a result of the COVID-19 pandemic, because in the past, if we look at history, the EU has often emerged stronger from crisis as member states realize the need for common action. What are then the external role expectations of the EU? I'm here drawing on a recent book that was edited by Chaban, Niemann, and Speyer called Changing Perceptions of the EU at Times of Crisis. So they have done a study in strategic locations worldwide of how the EU is perceived post-Brexit. And what's interesting is that, well, it has generated a mixed picture, but overall, the decision of the UK to leave the EU has not been perceived as a detrimental blow to the images of the integration project. Of course, an important factor on a bilateral level is always what the relationship is between the EU and that country where the study was carried out. And in many cases, the EU has been or is negotiating trade and partnership agreements. So that has, of course, a big impact on how the EU is perceived as well. But we can say that overall, the EU is post-Brexit not really perceived to be much weaker. And the external context might even be to some extent conducive to seizing new opportunities in response to these geopolitical changes that coincide with the time of Brexit. So what about the capabilities post-Brexit? I think we will have different presentations, for instance, on trade, so I can be very brief. But I think the widespread expectation that after Brexit, the EU might become more protectionist because the UK was a little bit of a free trader is not necessarily holding up. Well, we have to see. But because I think it neglects the future economic partnership, which is still uncertain. And also that in case of a harder Brexit, which is where we might be going, more pro-liberalization UK-based businesses might consider relocating to the EU 27 and therefore also lobby for a certain trade policy in the future. And also the rather complex process of trade policy making in the EU as an exclusive competence moderates the impact that Brexit might have on the interest constellations in the Council. And indeed, if you look at what happened after the Leave vote, it has not really affected EU's drive to conclude new free trade agreements. And the Commission's response to President Trump's trade wars has portrayed the EU as a champion of free trade and multilateralism. The key term of the recent policy review launched by the Commission in June is open strategic autonomy. So trade and investment policies probably likely become more assertive as well, but continuing to support rules-based trade. But new tools have actually already been launched before Brexit or the Geopolitical Commission took office. For instance, the new screening mechanism for foreign direct investments, a reform for trade defense instruments, and new tools in international procurement, the position of a chief trade enforcement officer, and also on the multilateral level, the EU has been active in supporting a reform of the WTO, trying to come up with interim arbitration arrangements, pushing for multilateral investment courts and so on. So generally, the EU in this field possesses capabilities to perform the self-perceived and expected role as a market or trade power, and it keeps also adjusting them. Now, very briefly regarding development cooperation, I have to say that the UK has been a major donor, still is a major donor, and it has played an important role also in defining the strategic approach in EU development policy, always being very development friendly in the past. Its withdrawal coincides with the negotiation of the multi-financial framework 21-27, and also of the successor of the Cotonou Agreement with the African, Pacific and Caribbean countries, or ACP countries, I should say. So among other things, we can see that the Intergovernmental European Development Fund for the ACP countries, to which the UK was a very big contributor, will finally, it looks like, be integrated into the regular budget, something that the UK might not have approved of, and thus be brought under the control of the EU institutions, which was so far not the case. And also other member states are more or less making up for the Brexit gap when it comes to development funding, and the allocation, I can't try to calculate it, will come up with a similar amount, comparable in the new neighborhood development in international cooperation instruments that is proposed, as compared to what we have currently under the 2014-2020 MFF combined with the European Development Fund. So there's not going to be a huge gap as such. Nevertheless, both the EU and the UK, I think, face a loss of expertise in this field, a loss of negotiation clout, as well as outreach and impact as donors and as norm entrepreneurs. But in the negotiations so far between the EU and the UK, development cooperation has really remained a footnote. So there's not much to be said about that. Now, finally, when I come to the third field, security and defense, the UK has often been seen as a brake on the development of a more integrated EU defense policy. And the Brexit shock has already led to a certain reinvigoration in this field. In 2017, the European Defence Fund was created, the Coordinated Annual Review on Defence, and the Permanent Security Cooperation, PESCO. And even those member states of the 27 that are not fully convinced maybe of the concept of European strategic autonomy have defense capabilities. We might also even see a new phase of Franco-German cooperation in this field. We will have to see. Now, being outside EU defense structures, the UK, of course, has an interest in a strong NATO and EU-NATO cooperation. However, here we still have the problem that this has for a long time been hampered by the dispute between Turkey and Cyprus. So it's not very likely to materialize soon. And then furthermore, it's also interesting that in 2008, the Commission proposed, so this is not decided, to pass from unanimity to qualified majority voting under the CFSP in case of human rights in multilateral fora, such as the UN, or sanctions policy and civilian missions. So there's a certain push to go further in security and defense. Finally, of course, also in internal security, the UK has made important contributions in the past to the area of freedom, security, and justice. For instance, with regard to the EU's counter-terrorism policy, and I think here Brexit is really bound to have a negative impact, especially on police cooperation, but also if you think of intelligence gathering, with the UK being a member of the Five Eyes group, with the US, Canada, Australia, and New Zealand, and the EU might lose access to that. Now, in a nutshell, the capabilities range from a strong toolbox in trade to a rather high reliance on member states' resources in security. But overall, I think the degree of EU activeness, even though it varies according to policy fields, is without the UK still considerably strong. And new capabilities have been created in response to new opportunities or new challenges. Also, the origin of some of these changes already date back before Brexit and are mainly driven by global developments. So to conclude, I would say that the UK's departure does not mean that the EU will become an irrelevant player in world affairs. And on the contrary, it even has the potential, and we have seen signs of it, to become a stronger international actor. The global strategy of 2016, which was adopted right after the Brexit referendum, expects EU external action to be guided by so-called principled pragmatism. This could also be seen as a further step to budge the EU's role from a mere market or trade power and normative power to becoming a more ordinary great power, if I may say so, with a new focus on potential security provision as well. And finally, of course, not only the EU is readjusting its role in world affairs, also the UK has to find new foreign policy roles for itself. And it has been trying to do so with global Britain, whatever it means. And also its development policy might be subject to change because there was a recent merge of the Foreign Office and the Department for International Development, which was also not appreciated by everybody. So I think the EU plays an important role in shaping this process also for the UK, for the UK's future role, because of the close bilateral relationship, because the UK is not going to be able to detach itself economically or politically from the fate of the European Union. So the two are bound, and they will also be shaping each other's roles in their interaction in the future. I think that's more or less what I wanted to say. So thank you very much.
Thank you. Thank you, Sieglinde Gstöhl, College of Europe. I'm sure panel members will have questions. Please reserve them until the fourth speaker has been, so that we can organize a debate. I would now like to invite Peter Holmes, who is also speaking on behalf of his co-author, James Rollo, of the University of Sussex, to take the floor. He will be addressing the question of Brexit and trade relations.
Well, thank you very much. It really is a great privilege and very interesting to be engaged with such a distinguished panel. And I must say, I really enjoyed Sieglinde's presentation, and I could probably spend a quarter of an hour sort of reacting to all the fascinating things she said, but I'll try not to. Perhaps we can be in touch directly. I do have some slides, which I'd be very happy to make available to people, but I think I will just use them as notes for speaking. This paper, as I said, is jointly with Jim Rollo, and we were really rather concerned whether we'd actually be able to write anything at all at this point, because we correctly anticipated, shall we say, that by now we wouldn't know where things are. And so rather than try and explain what's going to happen in trade between the UK and the EU, we thought we'd look back as to how we got to the point we're in at the moment, and with a very brief amount of speculation on what can come next. The first thing to say is that, surprisingly, trade wasn't a salient central issue in the referendum. I'm going to just briefly outline the argument. We saw at the beginning that trade wasn't such a central part in the Brexit debate. It was mentioned, but there was very little discussion at the time of the referendum what was going to be on offer, what sort of trade agreement we were going to have. But the themes in the Brexit campaign were take back control, and in particular control of immigration. And nobody really knew what the control was going to be used for. It seems like another world, but to think back to 2019, most of the discussions were about what was going to be in the withdrawal agreement, not what the final trade arrangements between the UK and the EU are going to be. Gradually, over time, the debate, with a jump in December 2019, there was a big jump from discussing the merits of particular arrangements to making sovereignty the fundamental aim of Brexit in all respects. The economic benefits became secondary. It was sovereignty for the British government. And given that we still don't know, when people say, you know, we've got to get rid of all these EU regulations, which regulations they want to get rid of, we're left with the fact that the one area in which the government really insists on its ability to deploy its own sovereignty is in trade policy. Striking new trade deals is a phrase you hear all the time, even though what it really means is trying to renegotiate the deals which we are losing by leaving. A deal with the United States has been a major goal, but and domestic regulatory policies are made almost secondary to the goal of pure autonomy in trade policy. And we just don't know where we're going to end up. But at the moment, as we look through the trade negotiations, we see that time and time again, the UK has insisted on regulatory autonomy rather than cooperation and well, regulatory cooperation. And though, as we'll see in the end, it hasn't given up on demanding rather strong market access conditions, even though it's not at this moment prepared to give up sovereignty in order to get there. So that's the outline. So let me move on to the context, which is that, as I said, in 2016, nobody really explained what Brexit was going to mean. This was partly deliberate, because in order to construct a coalition of Brexit voters, the Leave side had to both appeal to the anti-globalists, if you like, anti-immigration nationalist camp, and to a somewhat smaller global Britain campaign that wanted to have more globalization rather than less. So you had to have a fuzzy objective which appealed to two completely contradictory constituencies, the anti-globalization and the empire nostalgic people, and the global Britain buccaneers. Now, all the economic calculations showed that there would be a negative impact of any form of Brexit in purely economic terms, but the nature of the losses would depend on what kind of Brexit there was going to be. The economic modelling strongly suggested that the end of the customs union, the risk of restoring tariff barriers, was actually likely to be less damaging than the danger of introducing more non-tariff barriers. So always in terms of the modelling work, remaining in the EEA with not necessarily tariffs on British goods, but having complications of rules of origin and so on. That was always estimated to be less damaging than, or the step down to that was less damaging than the step down to a free trade agreement with no regulatory cooperation. But the Brexit campaign, the pro-Brexit side, would always dismiss these economic calculations by saying, oh, that's not what we're going to have. We're going to have frictionless trade. And there are even some extraordinary quotes from hardline Brexiters saying there's absolutely no need to leave the single market. That's not what we're talking about. And in fact, I think if you were to try and envisage what really was in the mind of the Brexit supporters, it was that we could have a free trade agreement, that's to say, no tariffs on British originating goods going to the EU, but no actual reflection on what rules of origin implied in this context, and some sort of single market arrangement with the if you like, the notion of the single market being reduced to a kind of trade facilitation concept, in which the single market didn't depend on common regulations. It just depended on minimizing the frictions and the paperwork, which allowed you to live with divergence. And we'll come back in a moment to the significance of mutual recognition, which the Brexiters constantly stressed. But so this was right at the beginning. There was Brexit was it was a menu with no prices, and in fact the contents of the dishes weren't very well described either. But so as we go through the May period, she was trying to put a shape onto this very vague program, and it was clear that Theresa May was trying to achieve well, her real aim was to try and get frictionless trade, the ability to sign up FTAs, free trade agreements, with third countries, and as much regulatory sovereignty as possible, but some form of a common rule book with the EU. And of course, no border between either Northern Ireland and the Republic, nor between Northern Ireland and Great Britain. Now, David Finnemore is going to be talking a lot more about this, but I would simply observe that as far as I could tell, these objectives were impossible to achieve simultaneously. So she came up with plans which included a temporary customs union between the UK and the EU to avoid having an Irish border or an Irish sea border, including some form of common rule book, which would minimize the regulatory problems of this. She invented something called a facilitated customs arrangement, which was a kind of VAT on steroids, where every single commodity would be tracked in every single transaction within Britain to see whether it was eligible for a UK tariff or an EU tariff. But all of these problems, all of these plans essentially ran up against feasibility and, above all, UK domestic political problems. And there was no alternative single proposal, no plan could actually command a majority. That was the thing. If you, the Remain was the largest single option, most preferred option, but it commanded less than 50%. None of the other options were greater than Remain, but no single option could command a majority in Parliament or in the public. So in 2019, basically, May collapsed, and we had the arrival of Johnson, who essentially abandoned. Now I'm now sort of moving into David Finnemore's territory, but from a trade perspective is the way I'm thinking. She abandoned the idea. So Johnson ended up abandoning the idea of completely free movement of goods between Great Britain and Northern Ireland in order to respect the promise of free trade across the border in the island of Ireland. But that meant that he was also abandoning the idea of a frictionless border between Great Britain and the rest of the EU. So it wasn't very clear exactly what Johnson did have in mind. But what's interesting is that he signed a new withdrawal agreement, which provided effectively for a border in the Irish Sea, but not one in the island of Ireland, and left unclear what the trade relations between Great Britain and the rest of the EU were going to be. What's interesting is that the political declaration of autumn 2019 promised a level playing field, in the sense of getting rid of the regulatory differences, or ensuring there were no regulatory differences that would justify or necessitate border barriers between Great Britain and the rest of the European Union, and the European Union, and which had been the harmonization, mutual recognition would which was necessary in the creation of the single market. Now, the British have always, since 2016, and to some extent in their earlier thinking, been obsessed with the idea of mutual recognition. That's to say, everybody does what they want, but things are very carefully labeled, and everybody agrees to accept everybody else's goods, provided it's clear how they're made and what's in them. And I've heard Fox in a sort of relatively small, Liam Fox in a relatively small gathering, talking about mutual recognition as the way forward. We don't have to have any sort of harmonization. We don't even have to have customs checks, as long as we all have authentic pieces of paper saying what our goods are, and allow the market to choose which goods are to be sold in each country. So when we look at the draft free trade agreement, which the British proposed, and compare it with the EU's draft, what's very striking is, as we said, all the level playing field provisions are left out. The draft UK free trade agreement is very clearly, it reproduces the terms of the WTO subsidies code and the GPA, the Government Procurement Agreement. It asks for no further commitments in those areas between the UK and the EU than are contained in the WTO. But it does ask for mutual recognition of testing and certification. That's to say, the draft FTA calls upon both parties to have their own separate rules and regulations, but to accept certification conducted in the other territory, where in the case where goods are produced to the importing country's standards. So the UK wants to be able, for example, to make the REACH regulations in the case of chemicals no longer mandatory, but it wants the EU to accept that if a British testing and certification agency says that a chemical product made in the UK does in fact comply with EU REACH rules, it should be allowed to be sold freely in the EU without further border check, except to make sure that there is paperwork confirming that this chemical product is safe. So the UK is also, whilst insisting that there must be a free trade agreement, not a customs union, insisted on rules of origin, which are extremely generous to a product that's made in the United Kingdom, specifically Great Britain, using imported parts and components. When we did a UK TPO briefing paper on this, the guy who's editing it put a headline on it saying, UK demands that goods made anywhere in the world can be labelled made in Britain and must go duty-free into the EU. I think it's a very slight exaggeration, but I think if the British could have that, that's what they'd like. So we have a situation where the UK is refusing level playing field demands. And when you go into the details of every small option on regulatory alignment, again and again, the British government's been insisting that we should diverge rather than cooperate. So the chemical industry is extremely worried that the British are going to insist on a separate chemical safety regime, which is going to be very harmful for British exports. Sorry?
Can you wrap up, please?
Yes. So there have been a whole series of cases in which the UK in the chemical sector, it risks not being able to sell to third countries where the REACH directive is the sort of the required thing. There's a new issue today, or yesterday in fact, where the government has slightly modified its demands that the so-called CE certification should be only using British documentation. So what we have is a situation where up till now, the British government has insisted on strong market access provisions into the EU, but no concomitant obligation for accepting. So really, if there is no deal, it's going to be because the British government has insisted on making sovereignty the crucial element in everything that affects trade. If there is going to be a deal, one side or the other is going to have to back down. It's imaginable that the the EU might be willing to relax its demands on state aids and only introduce countervailing duties when Britain actually does introduce unfair state aids. But it's, given Johnson's record in the autumn, it's equally possible that he might try to get a deal at the last minute by going back on his sort of blustering sovereignty demands. But whether or not he would be capable of making credible commitments, Jim and I and everybody we've talked to we just don't know. It's quite possible that a landing zone will be found, but if we don't get one, it's simply because the trade issue has become subsumed under the sovereignty dimension, and it's not easy to see how they're going to back out of that. Thank you.
Thank you very much, Peter Holmes, University of Sussex. Interesting times ahead, Peter. Well, I would like now to pass the floor to Catherine Barnard, University of Cambridge, who will be addressing, well, maybe not migration, but mobility, as she calls it. She will probably explain it. Catherine, are you there? Catherine, are you there? Catherine?
Yes, can you hear me?
Yes.
At the moment, thank you very much. I'd very much like to share my screen. I've got some slides, but you need to enable me to do it.
How can I do that?
Is it share screen?
Yeah, but I need your permission. Nanette needs to give me permission because she's the host.
Okay, I'm looking for that.
Nanette, you can find it under participants.
Under
the list of participants, you can grant access to individual participants if it's as a host.
I don't have that.
No, but you have participant.
I have participants, and I have two different boxes. If I see participant, I find here Professor Catherine Barnard. I can do.
Can you make her co-host?
I can make her co-animateur, as they call it here.
That's that.
I'll do that. Co-host. You're now co-host. Okay.
Yeah, we see. Perfect. We see the PowerPoint. Yeah.
And can you see it as a full screen?
Yes, full screen, and we can hear you too.
Marvelous. Well, thank you very much indeed to Nanette and to Jörg for organising and hosting this event. I know it's a nightmare pulling together a group of academics across Europe, and it must feel like herding cats when you're doing it at a time of COVID as well as Brexit. So thank you very much indeed to both of them. So I've been asked to talk about mobility rights, i.e. free movement, or mobility as it's going to be called in the future if there is some sort of future arrangement. And in particular, the interplay between the role of the Court of Justice and what the court has done in respect of mobility rights and what impact that's had on the decision for the UK to vote to leave the European Union. And essentially, my paper looks at three questions. The first one, to put it crudely, of course in the paper it's put in far more academic language, is why is the Court of Justice so unloved in the UK but not elsewhere? And I will talk a bit about the Court of Justice decisions in the field of free movement. It's part of the story, and actually the story is more complicated than that. I then will look at what the post-Brexit dispute settlement mechanism might look like. And what we'll see is it's very much, as Peter's been saying, a state-to-state dispute resolution mechanism. And this will have really quite serious impact on individuals who will not be able to bring any claims under any future trade agreement, because it is very much in the framework of a bog standard free trade agreement, such as the kind that the EU has with Canada and Japan, South Korea and elsewhere. So let's just start by looking specifically at the Court of Justice and essentially the genius of the Court of Justice and the way it works. And in order to understand why the court is so unloved in the UK, you need to understand a little bit about how the Court of Justice has worked and how those around the Court of Justice have worked. And there's a very famous quote written by the magnificent Eric Stein years ago, which is both poetic and accurate. And he says, he's talking about the court, tucked away in the fairyland Duchy of Luxembourg, and blessed until recently with benign neglect by the powers that be in the mass media, the Court of Justice of the European Union has fashioned a constitutional framework for a federal style structure in Europe. From its inception a mere quarter of a century ago, the court has construed the European Community Treaties, now the EU treaties, in a constitutional mode rather than employing the traditional international law methodology. Now, that brilliant quote neatly encapsulates the fundamental problems which the parts of the British public and the British press have had with the Court of Justice. It has been quietly working away, structuring, creating this constitutional framework, this federal structure for Europe, at a time when it's not clear that at least UK nationals were signed up to that as an overarching goal. And in this process, and of course inevitably because time is short, I will oversimplify, but in this process, the Court of Justice has transformed itself from an international tribunal of the kind that you might find dealing with international law disputes between states, to a constitutional court which allows access by individuals and not just states. And in that process, as Eric Stein indicates, the Court of Justice has constitutionalized itself and the European Union. And what we've seen over the course of the last, well, he says 25 years, of course it's now another couple of decades have passed since then, the EU has shed its skin of a mere international organization and has become very much a supranational power in the way that we've already heard from the earlier speakers. And it's done this by stealth, it's done this cleverly, and it's done this in a very effective dialogue between lawyers and courts in the member states. Now, there's an interesting narrative about how this has occurred, but just to put some headlines out there, it developed, I think, probably the most important principle of EU law, the notion of direct effect. So EU law can be enforced in the national courts, and the preliminary reference process has enabled the national courts to have a very powerful dialogue with the Court of Justice. It's also developed principles of supremacy of EU law, doctrine of human rights, doctrine of implied powers. These headlines, which of course for those of us who teach EU law or EU matters, of course this is bread and butter stuff. But if we take a step back, we should never forget just how dramatic this has been in contrast to what is done under international law and what is done under free trade agreements and what is done under the WTO. The really interesting question is, why did states, member states, sign up to this? Did they actually sign up to this? And why did the member states actually allow this to happen? just contrast what I've just very briefly outlined with what's going on at the WTO. Now, WTO has a relatively sophisticated dispute settlement understanding, and that dispute settlement understanding lays down the processes for resolving disputes. To put it crudely, there's a process of consultation followed by a panel and then appeal against the panel's decision to the appellate body. And those bodies make recommendations to the dispute settlement body, which makes the final decision. Now, as you know, the US is really trying to blow the WTO's dispute settlement understanding out of the water. It's got lots of complaints about the appellate body, and it says at the moment it's blocking any appointments to the appellate body, which means the appellate body is down to one appellate person, and therefore it cannot actually sit at the moment. And as you can see, I've summarized on this slide some of the US criticisms of the appellate body, that it's engaged in procedural violations, it's engaged in substantive violations of WTO law. And I think most relevant for what we are interested in is that the US also accuses the appellate body of interpreting WTO agreements rather than simply applying them. Now, for lawyers, this is a rather odd concept, but the US says interpretation should be a political matter, not done by the appellate body. And also the appellate body should remember it's not a court, it's composed of persons, not judges. So the interesting question then is, why is it that the EU 27, 28, the member states haven't reacted in the same way against the Court of Justice? And I think it's got a lot to do with the fact that the Court of Justice, quietly, as Eric Stein said, tucked away in Luxembourg, which a lot of people couldn't even place on the map, was just getting on with this very, very quietly, taking a highly legalistic approach to interpretation of the project, and the sort of purity of law could not be interfered with. Think about the integration through law project in the 1980s. And I think what's absolutely crucial is that the court was surrounded by and interacting with, and there was quite a lot of cross-fertilization between EU lawyers, the judges at the court, EU officials, particularly at the Commission, all working together, and essentially all of them having some sort of vision of the EU as a benign force which would lead to peace between nations. And the best way of doing that was to have this highly integrated European Union. And all of this was done through the interpretation of the law. And so it was done as interpretation, and the neutrality of law, Burley talks about the neutral zone of the rule of law, enabled it to mask what was really going on, which was essentially a quite significant power grab by the European Union. And what's so striking is just how little backlash there was by any of the member states. It's really striking that you don't get a really, there's so little criticism of the court. Perhaps the most famous example is the Rasmussen book of 1986. It's the first time you start seeing the literature, some real efforts to say what on earth is going on in Luxembourg. And you might wonder, why has there been so little backlash? Well, I think there are various answers. You could say it boosted the internal processes of the member states, who recognized that reforms were needed, and it was good to use the EU as the whipping boy for that reform process. It also empowered local courts because, of course, they liked the fact that if they were a very junior court in the national legal system, they could have real power and influence by sending a case off to Luxembourg. And it's also maybe because of what some describe as transnational incrementalism. In other words, where some big courts in Europe accept what the Court of Justice is doing, others follow. Now, what about the UK's response to it? Now, of course, there is growing concern in the UK. And Peter, I think, very nicely explained the context of the 2016 referendum and the increasing desire for sovereignty. But what's interesting is how the UK's reaction to the Court of Justice and the UK's increasingly wary attitude towards mobility rights came together, because what we see is that you have the court engaging and making very significant rulings in the field of free movement. The court engaging in its constitutional interpretation. Look at the decision in Grzelczyk, for example, where the court talks about union citizenship becoming the fundamental status of nationals of the member state. You've got this very constitutional language, and also doing some really radical things to shape and give substance to the Article 21 rights in decisions which are known and loved by immigration lawyers, but hated particularly by the UK Home Office, decisions such as Baumbas Chen, Zambrano, Surinder Singh, and so forth. And what there was a sense of was that the UK was losing control of its borders. Now, of course, it's infinitely more complicated than that, but the simple narrative was very appealing, that the EU was interfering in this area of great national sensitivity, immigration law. And remember that the UK took very, very large numbers, welcomed very large numbers of EU migrants, EU nationals from 2004 onwards, far more than the Blair government had led people to expect. And they were getting all of these quite dramatic rights. Now, we also know that the court did something of a volte-face in about 2014, 2015 in decisions like Dano Bray and Commission in the UK. But by then, it was too little, too late. And in the run-up to the referendum, you can see the migration issue, as Peter's already said, became front and centre of the discussions. And I think it's quite striking, if you look at the balance of competence review, you see how the hostility to the court and the hostility to free movement come together. The balance of competence review, which was done, commissioned by the government in the run-up to the referendum, said the court's case law, which has interpreted the right to free movement broadly, has had the effect of limiting the ability of member states to control immigration from within the EU. And so what you see, this is the resonance of the take back control, the sovereignty issue. It's the court's fault, and it's also free movement that's caused serious problems in the UK. And just to give you one taste, this is the Daily Express, which is a strongly Leave supporting newspaper.
2 minutes.
Sorry?
You've got 2 minutes.
That's fine. Here you've got the Daily Express making this case. Look at the effect of the Court of Justice. Britain has lost more than 75% of EU court cases. We've lost control, and you can see that in the quotes. So it's not surprising that the court became the bête noire and of course became a red line for the UK. But what is surprising in the withdrawal agreement, that's the Article 50 text, which Peter referred to, despite the fact that the ECJ was allegedly a red line, in fact, it's referred to 64 times. And indeed, there is still an important role for the Court of Justice in adjudicating on the withdrawal agreement itself, if there's a breach of the withdrawal agreement, and there's an issue of EU law engaged. And indeed, in respect of EU nationals who are living in the UK, there is a special jurisdiction, and there will still be a role for the Court of Justice. References to the ECJ for 8 years after the end of this year, and notions of direct effect and supremacy of the withdrawal agreement will carry on applying. And of course, this was an agreement which was largely negotiated by Theresa May, but of course it was finally signed by Boris Johnson. And what we've seen is that those red lines, anti-Court of Justice, turn pink in the withdrawal agreement, but are likely to turn back to red in the future agreement. Now, what I want to say here is, of course, we don't know what will be in any free trade agreement. but it's very likely that anything in a free trade agreement will be very thin indeed. It will bear no resemblance at all to free movement. It will look much, much more like what you find in the EU-Canada Free Trade Agreement. And that is essentially about provision of services, and that there will be very limited mobility rights purely in the context of trade in services. And so there might be bits and pieces about youth exchanges and so forth, but in essence, it will look very much like the very limited mobility provisions in the Canada Agreement. But the crucial issue, which brings me back to my starting point, what will be the remedies in the any future trade agreement? Well, the remedies will look very much like the remedies, or it's likely that the remedies look very much like the remedies in the CETA, the EU-Canada Free Trade Agreement. It will be something like along the lines of consultation, mediation, followed by some sort of panel. There will be no appellate body, there will be no dispute settlement body, but crucially, it will be state to state. And what that means in the end is that the individual is the loser. We have gone back from supranationalism, constitutionalism, empowering the individual through the principle of direct effect and supremacy, to reversion to a much more standard international law norm, state to state, and where the individual is totally disempowered. So what we've seen is that the grand narrative of constitutionalization has been disempowering, not enabling. I'm sorry for the typo there. And the courts, where many EU lawyers would praise the court for its constitutional developments that have been highly effective in empowering the individual, have actually led in the UK, amongst those who voted Brexit, to a desire to leave what became seen as a federal, quasi-federal organisation, which was undermining national sovereignty. Thank you very much indeed.
Well, thank you very much, Professor Barnard, Cambridge University. I would like to immediately pass the floor to David Finamore, who will be speaking on Northern Ireland. I am aware that we will be running out of time soon, so I ask you for your understanding that we will be taking a bit longer because there will be the debate, and then we will be handing over to a new editorial team. So please stay on the line. David, are you there?
Yes, thanks very much, Nanette. I'm going to share a few slides as well. Okay. I suppose if we think back to 2016 and the referendum, I doubt many people at the time would have been thinking that 4 years later we'd be discussing with such prominence Northern Ireland's position within the withdrawal process. I suppose one of the surprises of the last 4 years is the extent to which the Irish dimension, the Northern Ireland dimension to Brexit enjoyed such prominence in the negotiations and in the debates in the UK. For those of us who are interested in it, it was proved to be a very fascinating process indeed. Also what I find quite interesting, indeed fascinating, is the result of that and the arrangements which have been put in place for Northern Ireland in the context of withdrawal. There's a huge amount of uncertainty about the future nature of the UK-EU relationship. The one thing of which we are sure are the arrangements which will be in place relating to Northern Ireland, because these were set out in the dedicated protocol to the withdrawal agreement. What I'm interested in doing in the paper is exploring what the implications are of the withdrawal agreement and the protocol for Northern Ireland. What does this mean for Northern Ireland's position? And does it create a unique status because of the obligations in the protocol for Northern Ireland as a place between in the UK-EU relationship? I think there's also a supplementary question here about what it, as to what this tells us about the EU in terms of the flexibility it's willing to show with regard to integration with third countries. Because I think in many respects what we have here in the protocol is a relationship which is unprecedented in EU external relations, whereas a subnational entity within of a state is accorded particular form of integration with the EU. Okay, so the essential argument of the paper is that we do have this unique position being established for Northern Ireland. It's part of the UK, so it's part of a non-member state, but it is still integrated quite heavily with the EU in a relationship which has an element of inbuilt dynamism to it, and arguably also has the potential to develop further, albeit in the context of the UK-EU relationship and dependent on that UK-EU relationship. So what the paper does is it looks at what the challenges are or were for Ireland, Northern Ireland, posed by Brexit, recaps on those. It looks in particular then at what the protocol entails, and then moves on to some of the questions about, okay, well, what's going to happen next with the protocol? It's fair enough negotiating a legal text, but you then have to implement it. And as we're probably already aware from some of the debates which are ongoing, there are a series of consequences following from the protocol, which many people underestimated. And some of those consequences will have quite significant economic impacts, particularly those relating to the movement of goods between Great Britain and Northern Ireland. So yeah, I want to work through these and then offer some concluding remarks at the end. In terms of the challenges that Brexit posed, these were quickly identified, certainly by the Irish government, the EU, and gradually over time by the UK. I think it's fair to say prior to the referendum, no one had really thought through what the implications of withdrawal might be for Northern Ireland. And as I say, a number of issues were quickly identified. Obviously, what has attracted a lot of focus has been the border. The immediate concern, particularly with the UK committing to withdrawing from the customs union and the single market, was what that would mean for the movement of goods across the essentially invisible border on the island of Ireland. And as we're well aware, the prospect of a return to checks and controls was soon identified, and this would pose a major concern on the island because the invisibility of the border is very much seen as integral to the peace process. We then had issues around how you uphold the 1998 Belfast Good Friday Agreement and the obligations within that. How do you sustain, without the context of shared integration through EU membership, North-South cooperation? And I think one of the a key project which was undertaken in 2017 was to actually map the extent to which a lot of North-South cooperation on the island of Ireland is contingent on EU membership. There's also a debate as to the extent to which the UK withdrawal would disrupt the all-island economy, and also very much from a UK perspective, the argument that how do you maintain the common travel area in the context of UK withdrawal. Arrangements which allow essentially for the free movement of British and Irish nationals across these islands. Okay, so this provided a context for the withdrawal agreement or the withdrawal negotiations, and the question was, how do you begin to address a lot of these challenges which hadn't necessarily been thought through in advance of the referendum in the context of the UK's withdrawal? One of the interesting paragraphs of the guidelines which the European Council adopted very swiftly after the UK signalled its intention to withdraw and triggered Article 50 was this paragraph, which talked about the unique circumstances on the island of Ireland and the need for flexible and imaginative solutions, which would include avoiding a hard border, but also in respecting the integrity of the Union legal order. The question which a lot of us were posing at the time was, well, what can actually be achieved under this rubric of flexible and imaginative solutions? And how committed was the EU to pursuing flexible and imaginative solutions, particularly while it was insistent on respecting the integrity of the Union legal order? Okay. In many respects, this was unprecedented. situation to be in, the willingness of the EU to consider discrete arrangements, differentiated arrangements for part of a non-member state. Okay. Now, the outcome of this ultimately was the protocol on Ireland, Northern Ireland, and clearly that is something which has attracted, elements of it have attracted a considerable amount of attention, notably on the trade side of things. And I'll just run through here some of the key features of the protocol, which highlight the extent to which Northern Ireland will be in a different relationship to the rest of the UK, particularly regarding goods. First off, we obviously have Northern Ireland being part of the UK customs territory. This is stated very clearly in the protocol, but importantly, applying the EU customs code. In effect, therefore, de facto part of the EU's customs territory. Okay. Significant commitment on the part of the UK government. Picking up on what Peter was saying earlier, the UK rejecting the idea of staying in the customs union, yet effectively keeping Northern Ireland in the customs territory of the EU in order to avoid any frictions on the border between north and south of the island. Secondly, you've got the UK government commitment to unfettered access to the rest of the UK market. I think what's often overlooked in debates and discussions around the unfettered access is that, according to the withdrawal agreement, this is a UK government commitment. It is not a shared commitment of the UK and the EU. It is up to the UK government to determine how that unfettered access can be assured. And there's obviously clear question marks as to whether that can be, given the UK's obligations to implement the EU customs code in Northern Ireland. Also necessary in order to allow for the free movement of goods across the border on the island of Ireland is continued dynamic alignment of Northern Ireland with the EU acquis relating to the free movement of goods, including sanitary and phytosanitary arrangements. Very significant obligations or commitments there on the part of the UK, effectively retaining Northern Ireland as part of the internal market for goods. What we also have beyond on the goods, on the regulatory alignment regarding goods, we have the application of EU VAT and excise rules applying. We also have EU state aid rules applying, and we also have alignment with a number of EU regulations to ensure the continuation of the single electricity market on the island of Ireland. And obviously, contrasting with the position which the UK as a whole wants to adopt regarding the Court of Justice jurisdiction, we have a situation under the protocol where the Court of Justice jurisdiction continues to apply in Northern Ireland in respect of the EU law which is being applied under the protocol. Moreover, there are in the protocol a range of provisions which support the maintenance of necessary conditions for North-South cooperation on the island of Ireland. These are far less developed than many people anticipated, and indeed there's arguably a need to flesh out those conditions and the arrangements for their maintenance in due course. We also have in the protocol, and this is one of the key changes introduced as a consequence of Boris Johnson coming to power and securing agreement on a revised withdrawal agreement, and these are the democratic consent mechanisms. These are significant, and I'll talk a little bit more about them in a moment, because they essentially introduce a degree of uncertainty into the continued operation of the protocol. Every 4 years, there's an opportunity every 4 years for members of the Legislative Assembly in Northern Ireland to vote on whether they want to continue with the application of core elements of the protocol, essentially relating to the free movement of goods. Moreover, what we have in the protocol are a series of dedicated institutional arrangements for the management of this aspect of the UK-EU relationship. And I'll just a short slide here on to flag those. You have a UK-EU joint committee, you have a specialised committee on Ireland, Northern Ireland, but what you also have feeding into it are a series of other bodies which already exist under the 1998 Good Friday Agreement, so the North-South implementation bodies and the North-South Ministerial Council, which brings together ministers from Northern Ireland and Ireland. Moreover, you've got a number of human rights bodies feeding into the process. But then also bottom left there, you have quite a unique arrangement in what is known as the Joint Consultative Working Group, which is a form of decision shaping opportunity for representatives of the UK in respect of Northern Ireland coming together with Commission officials to discuss the application of the protocol, but also future legislation which will apply to Northern Ireland as a consequence of the obligations the UK has entered into in the protocol. Okay, so this set of institutional arrangements, I would say, is pretty unique in EU external relations, something which is dedicated to the governance of arrangements affecting a subnational entity of a non-member state. It's going to be interesting to see how these are implemented. Okay, 4 key points I want to, or key questions I want to raise here about what's going to be happening under the protocol, because these are novel arrangements. They do raise questions as to what the implications will be for Northern Ireland, for the UK-EU relationship. And they are going to be quite important because of the democratic consent mechanism which exists in the protocol. Moreover, they're going to be significant, I think, for the acceptability in Northern Ireland of the protocol itself. A first key issue which is having to be addressed is the whole question of implementation. And I think the evidence from this year is that the UK and the EU have diverging interpretations of what the protocol entails. For the EU, there's a set of legally binding obligations and commitments which need to be implemented. And the UK, as a former member of the EU, knows how the Union Customs Code should be implemented. For the UK, however, it sees the protocol far more as a set of arrangements which have been agreed and which you now need to negotiate on how they need to be interpreted. And this is causing a certain amount of tension between the UK and the EU. The most obvious set of arrangements where there's contestation as regards implementation are the arrangements regarding the application of the Union Customs Code in Northern Ireland and the extent of the checks and controls which are needed on the movement of goods between Great Britain and Northern Ireland. For those of you less familiar with the provisions, essentially tariffs will be applied to goods at risk of onward movement into the single market. And the point is often made that Northern Ireland is so small that to get any good entering Northern Ireland is at risk of movement into the single market. Moreover, what's often missed in a lot of the discussions here are the arrangements for goods which do not move between Great Britain and Northern Ireland directly, but instead move, as a significant proportion of the traffic does, across the island of Ireland. And there's still, this is a particular concern for businesses in Northern Ireland, still a lack of clarity about exactly how what formalities will be required and how those formalities will be implemented on the movement of goods. Okay, so there's an implementation phase which is proving problematic and is raising lots of questions. Second point to make here is to ask how likely it is that the arrangements put in place for the protocol how likely they are to be with us for a significant period of time. Are they effectively a permanent set of arrangements, or has the introduction of a democratic consent mechanism turned them into something which could essentially be temporary? And as the key concern here is that if you remove the protocol arrangements, we are essentially back to 2017-18 and working out how do you avoid a hard border on the island of Ireland, because the assumption clearly is that the UK-EU relationship is not going to involve the United Kingdom in a customs union relationship with the EU, or retaining the level of regulatory alignment such that you can have frictionless movement of goods across the border on the island of Ireland.
Can you finish, David?
Sorry?
Time is running out.
Okay. So 2024, we will have the first vote in the Northern Ireland Assembly on whether to maintain the key elements of the protocol. What's important to note there is that the outcome will depend very much on the composition of the Assembly, the implication of which is that the 2022 Northern Ireland Assembly elections could have as a core focus positions on the protocol. So whereas the protocol is designed to sort of maintain the status quo on the island of Ireland as much as possible, the protocol is highly contested and is likely to lead to further political divisions in Northern Ireland. Third point here is whether is the extent to which the protocol is dynamic. We have regulatory alignment with the single market acquis relating to the free movement of goods to be implemented. But there's also the question as to the extent to which the protocol provides a framework for further differentiated integration of Northern Ireland with the EU. That is obviously going to be a political as well as a legal question, but also it's going to be contingent on the need to possibly have some differentiated arrangements for Northern Ireland will be contingent on the future UK-EU relationship. One point to raise here is one of the things which is absent from the protocol, and that is the arrangements for the free movement of services. Despite the reference to the protocol supposedly supporting the all-island economy and minimising frictions, the absence of free movement of services is a significant obstacle for the promotion of the all-island economy, and also complicates the movement of goods as well. Okay, final point here was that clearly the arrangements are between the UK and the EU in respect of Northern Ireland. The protocol did not receive support from any member of Parliament when the withdrawal agreement was approved in the House of Commons earlier this year. And so there's a sense that there is a need for the protocol to be legitimised within the Northern Ireland, and to do this, there needs to be arrangements put in place such that the voice which comes through to the EU in the various mechanisms, the institutional framework, is generally a voice of Northern Ireland and not simply a voice of the UK government. And I think there's some interesting work to be done here about how that can be achieved. Okay, so just by way of conclusion, I think what we have here is a very interesting set of arrangements that have been negotiated in the withdrawal agreement for Northern Ireland. They do address a significant number of issues that Brexit poses, but as was noted earlier, I think by Peter, the fact that the UK is leaving the customs union, leaving the single market, means to say that there has to be friction with trade somewhere. And what we have in this particular relationship is the absence of the friction on the north-south border on the island of Ireland, but the imposition of frictions on the movement of goods between Great Britain and Northern Ireland. How that is going to play out in terms of the economic implications, it's going to be interesting to see. Final point relates back to the extent to which there is flexibility and imagination here. The fact that the UK is obliged to implement the Union Customs Code, there's continued dynamic regulatory alignment with the EU, I think is a reflection of how little the EU was willing to move away from EU standards and EU norms and maintaining the integrity of its own legal order in demonstrating flexibility in how to address the Northern Ireland-Irish dimension to Brexit in the withdrawal agreement. So interesting set of arrangements. Be very interesting to see how they are implemented in due course and what this means for Northern Ireland's position within the UK-EU relationship. I'll finish there. Thank you.
Thank you, David Finnemore, Queen's University, Belfast. So time is moving on. We are now entering into the debate, and joining us for the debate will be Ramses Wessel from the University of Groningen and Steven Blokmans from SEPS. So are you there? Are you both there?
Yes, absolutely.
Okay, yeah. Great. Welcome to the debate. I would invite every one of you to pose questions basically to the presenters, any order you like, relating, of course, to their presentation, and sharing your take on it. Who wants to take the floor?
If you allow me, Nanette, then I might jump in. Maybe linking up to, well, two things. David's point, he alluded to the unique feature for EU external relations of this institutional arrangement of the consultative working group under the UK-EU Joint Committee as applied to Northern Ireland. And I would simply, in the spirit of the 25th anniversary of the European Foreign Affairs Review, and the definition of a future research agenda in this particular field, like to ask the other speakers whether they could pinpoint one unique feature, an innovation in the field of EU external relations that they have spotted in their particular areas of study.
Who wants to take the floor on that one? Or shall we take some more questions before? Yes, Catherine Barnard.
Thank you. Thank you for those fascinating presentations. I want to come back to David Finnemore, and I thought it was fascinating what you were saying about the key question is what's going to happen in the 2022 Northern Ireland Assembly elections and how that will impact on a vote on continued consent for the Northern Ireland Protocol in 2024. I wonder if you could say a bit more about it. And I wondered too if you could say anything about how the institutional arrangements are actually working at the moment. You had that very nice slide of all of the different bodies which are involved. Has COVID meant that they're not actually meeting with each other, or are they meeting? And is there evidence that the Joint Committee is actually functioning?
Any more?
Okay, yes, come in there. Yes, Catherine, thanks for the questions. The Joint Committee has been meeting, as has the Specialised Committee. The Specialised Committee has met twice. The Joint Consultative Working Group has yet to be established, which is causing a degree of concern because we're already seeing a certain amount of a number of EU proposals which will affect, will have to be applied under the protocol. The early meetings of the Specialised Committee have focused very much on implementation and preparation for a number of decisions which actually have to be taken by the Joint Committee before the end of this year, certainly around what goods are classified as at risk of onward movement into the EU. Also arrangements for agricultural subsidies to producers in Northern Ireland, because obviously the cap will not apply to Northern Ireland, but you want to ensure a degree of level playing field for agricultural producers and agricultural trade on the island. There's a very interesting question about fisheries, which still has to be resolved. And also there are some other arrangements around actually how does what arrangements are put in place such that the Commission can monitor the implementation of the customs code in Northern Ireland. And there was an earlier debate this year as to whether Northern Ireland should, or the Commission should retain, or the External Action Service should retain an office in Northern Ireland to facilitate that. So yes, they are functioning. Though it's very, very difficult from our perspective to see what's actually going on inside those meetings, because whereas you get statements coming out for the Joint Committee, they tend to be very, very brief and quite perfunctory. Yet there's obviously very important work going on. One would hope that in due course we'll get greater access to that. I suppose one point to note about both the Joint Committee meetings and the Specialised Committee is they do have the UK government delegation does include representation from Northern Ireland, which ensures that that voice is at least present. How much space it is given in the meetings is another matter. On the 2022 question, the democratic consent, under the democratic consent mechanism, if there is a majority of members of the Northern Ireland Assembly supporting the continued application of the protocol, then you can go, then it is applied for another 4 years. And then you have another vote after another 4 years. If, however, you have what we refer to as a cross-community support for the protocol, which is essentially a majority of those who designate as unionists and those who designate as nationalists, then the next vote is postponed or only takes place after a further 8 years. So you actually get a little bit more stability into the process. At the moment, we tend to have unionists opposed to the protocol and nationalists and those who do not designate as nationalists or unionists as being supportive. So at the moment, there seems to be a majority in favour, likely to be a favour of the continued application of the protocol, but not enough to necessarily secure the cross-community support such that you could then have the next vote after 8 years. So you then lock yourself into this process potentially of a vote every 4 years. And in the intervening 4 years, in the intervening period, you have an assembly election, which is going to determine the composition for that vote coming further down the line. So if the protocol continues to be contested, it could be the permanent feature of the political debate in Northern Ireland, which is not a healthy environment to be in when you're trying to put in place a set of arrangements which provide a degree of stability and certainty.
Yeah, David, what do you think will happen in the case of non-renewal of the agreement?
Well, the default position is that 2 years after that vote, the protocol, Articles 5 to 10, which are the core elements around regulatory alignment and customs code, will no longer apply. Now, what that means to say is that the Northern Ireland's position vis-a-vis the EU will revert to the UK-EU relationship and whatever's in place there, unless agreement is come to in the meantime on some alternative arrangements. Now, if Northern Ireland simply reverted to the UK-EU relationship, given that we expect that to be the UK outside the customs union, not involved in regulatory alignment, you therefore have a hardening of that border on the island of Ireland. Your checks will move from the the GB, Great Britain to Northern Ireland, they will move to Northern Ireland to Ireland. And we'd have to have physical infrastructure, presumably, on the border in Northern Ireland. And that is clearly one of the key things which we were trying to avoid in the adoption of the protocol, because of the symbolic importance, at least, of no physical infrastructure on the border here for the peace process.
Okay, thank you very much. Perhaps Peter, do you want to also give your take on the question by Stephen Blockmans?
Yes, thank you very much. Absolutely fascinating series of papers. I have a response to Stephen and a question for David, if that's all right. Is there anything unique in the trade relation? I think it's an interesting issue because the British government insists it's only asking for what's in existing FTAs. I think that is not true. I think the details of the mutual recognition of testing and certification, which the British government is asking for, go way beyond. And obviously the British government have cherry-picked all sorts of elements in that area. But they're insisting they're only asking for what the EU is offering. On the other side, the EU is insisting that its models must be used. So I think that's an interesting tension. If I could just put a question to David, if I may. I was thinking back to, I think it's the December 2017 joint report, which contains in it a statement that everything there is a commitment of both sides, irrespective of any subsequent agreement. And I just wondered what the significance of the hangover that agreement is. It does refer to there being no hard border. And I thought I saw somewhere something in it about the commitment to an all-island economy, which implies services. So have we kind of gone back on that 2017 agreement, or has it now been forgotten?
David.
Okay. Yes, you're correct, but if we go back to the 2017 joint report, there's a reference to the all-island economy, and if we look at the Theresa May version of the withdrawal agreement, the protocol there has a reference to the all-island economy. That reference was subsequently removed. Okay. However, there are obviously clear concerns about how do you address that commitment back from 2017. One of the interesting developments when the council adopted the decision on implementation, on the adoption of the withdrawal agreement, is there's a paragraph in there which allows Ireland to seek permission from authorization from the council to conclude a bilateral agreement with the UK in areas of exclusive EU competence to implement or to achieve the objectives of the protocol. Now, the understanding is that this creates some space in which there may be arrangements put in place simply for the implementation of the protocol on the island of Ireland, which could involve some aspects of provision of services. We've not seen anything formal yet to indicate what might be done using that option in the council decision, but it's going to be very interesting to see, because as indicated, traders are already concerned about how you move goods if you do not have the free movement of services. Equally, if you do not have the free movement of people, because whereas the common travel area allows the free movement of British and Irish, it does not allow for the free movement of the EU nationals across the border. Okay, so yeah, we'll be interested to see how this evolves in due course. But I think as people have looked more and more at the protocol, they realise what it doesn't include, as opposed to simply accepting what it does include.
I see Sieglinde Gstöhl raised her hand. Sieglinde?
Yes, thank you. To come back to Stephen's very good question, I think Peter already pointed out to trade, and there's also a lot of new things, as David just said, with regard to Northern Ireland. If I think of security and defense, what I have not mentioned is, for instance, the European Intervention Initiative that President Macron had launched in 2017. And it was upon invitation only, and the UK was invited. So it's for armed interventions and stabilization missions. So to be able to, so that there might be more ad hoc cooperation also with the UK, or external differentiation, if you want to call it like that, in addition to what's going on inside of the EU in terms of internal differentiation, such as PESCO or CARD. And other things might happen with development cooperation as well between the UK and the EU. We don't know yet. So there could be new forms of cooperation as well, even though the UK is outside in other areas. And one point that was actually triggered by Catherine's presentation that struck me a bit is, to what extent is the UK actually, after almost 50 years of EU membership, closer to the US position, and especially under Trump?
Maybe Catherine, do you want to reply to this one?
I mean, I wouldn't like to give a blunt answer. The simple answer would be to say yes, the UK is going down the US line, because I think that would be simplistic, not least because the UK is allegedly a great supporter of the WTO and sees Brexit as an opportunity for the UK to have a seat at a global table and be highly influential at a global table. And so you don't see the UK making rude noises about the appellate body. And indeed, the UK has put forward Mr. Fox, who Peter Holmes mentioned, as a potential candidate for the currently vacant post of Director General of the WTO. And so, I mean, I think it says quite a lot about the current rather shambolic nature of the UK government, that I understand that Mr. Fox's application got in at the 11th hour, 59th minute, and involved somebody running down the street to try and get it through the letterbox of the headquarters in Geneva, which is not the way that traditionally UK has done things. So there's of course a huge amount of attention to what's going on in the US, and looking at the US and seeing Mr. Trump's brand of populism, which we see to an extent embodied in Mr. Johnson as well. But there are key differences, especially over the WTO. I don't know if Peter wants to add anything to that. Maybe I've misrepresented this.
Well,
No, he's in agreement.
Well, I think one of the external relations things that have not been mentioned so far, although both Peter and Catherine mentioned the importance for the UK of taking back control, is the issue of refugees. Because after the end of the transition period, the Dublin regulation will cease to apply to the United Kingdom. So one of the issues which will be arising is, have there been any proposals to replace the arrangements between the UK and the EU? And also what happens if there won't be anything agreed? Will it then become easier to respond to the plight of asylum seekers, or will it become instead much more difficult? I think this question is most easily addressed to Catherine, but you didn't deal with that because you were dealing with mobility in the sense of economic mobility, but maybe you want to say something about it.
Yes, thank you. Obviously, we do not know what will be replaced, what the UK intends to put in place by the Dublin regulation. As always, it's almost like Christmas that comes every year. Every summer, there are headlines about illegal immigrants, as the UK government calls it, crossing the channel in boats. What we're seeing is the anti-immigrant rhetoric being ramped up. And I've often thought there was a lot of confusion at the time of the EU referendum about what migrants were coming to the UK. And the UK, the Brexit campaign was very effective in diluting the difference between EU and non-EU migration. And the figures that were bandied about often included non-EU migration, over which the UK government still has full sovereign control. Ironically, the volume of non-EU migration has gone up quite considerably since the referendum, because jobs which were previously being done by EU nationals are now being done by non-EU migrants because EU nationals have gone home. So we don't know what will replace Dublin at the moment. It's not being properly discussed. And also we don't know what's going to replace the European arrest warrant, which is another dimension on the internal security front, which is of course an absolutely major issue and something I think the UK is one of the largest users of the European arrest warrant. So losing that as a possibility is really very serious for UK law enforcement. So there is a vast amount of uncertainty that we are facing going forward, and this will take years to play out.
Thank you very much. Unfortunately, we are almost run out of time. A little bit of time left. I would like to give the floor to Jörg Monar to say something, maybe to wrap up the thing. And to address also our new editorial team and to give them a message of congratulations maybe and continuation. Jörg, are you there to do that? Are you ready to do that?
Yes. Well, first of all, I found the papers really all fascinating, very substantial. When I was a student, one of my professors told me, well, as a future academic, you are not allowed to speculate, but you can engage in educated guesses. And I think these were very, very, very educated guesses, which we have heard. So thanks very much for this. And I'm sure it will be a splendid anniversary issue of the European Foreign Affairs Review. So many thanks to the contributors. I would also like to thank UASIS for having accepted this as a non-traditional panel proposal. What I can say is that Kluwer Law International had planned to offer a reception after the panel. So unfortunately, we are also going to miss out on the reception which the publishers would have offered. And personally, I very much regret that I've missed an opportunity to come to Belfast. I've never been to Belfast and was greatly looking forward to this. So, but just to say thank you to UASIS and for having made this possible. And then I would like to say that both Nanette and I, we are really very happy that Stephen and Ramses have agreed to take over the European Foreign Affairs Review. I warn you, it will be quite a bit of work. we have experiences ourselves, but it's also very worthwhile. So we really think we have an excellent team to succeed us. So we are finishing the first quarter of a century, and you are taking the review into the second quarter of a century. So all good wishes will be with you for this. And the final point I would like to make is to really thank Nanette Neuwahl because she made it possible that all this was arranged on a remote basis. I was very much taken up by my final duties at the College of Europe, so I was not able to do anything for making this technically possible. So many thanks to you, Nanette. And also just to say, Nanette came in as a joint editor in 2007. And Nanette, it has invariably been a great pleasure. So thanks very much for 13 years of cooperation. So I would like to finish with this personal note and hand back to the chair.
Okay, well, let's wrap up. It won't be finished because there's so many questions to ask. It's just that the time ran out. So I say goodbye to everybody, and we'll stay in touch by email, as we have been for the last couple of months. And I wish you a good start of the new academic year. And thanks also to UASIS for taking this video further. Thank you. Bye-bye. So now there's no more